Good afternoon, ladies and gentlemen, from the beautiful city of Johannesburg, South Africa. And welcome to the second edition of Stren Blan Partners Africa Turnaround and Restructuring podcast. I am very delighted to be joined by two very incredible professionals in the turnaround and restructuring world. It's a great honor to have them sit with me to discuss this very interesting topic, which is why African companies would typically have good turnaround and restructuring plans at the end of the day eventually fail. I'm delighted to be joined today by Joe Michel Maris, who is the African turnaround and restructuring leader at Deloitte, here based here in Johannesburg, South Africa.
I don't know where I'm based. It's a bit of Cape Town, it's a bit of Johannesburg.
All right. Yeah, well, at least based in South.
I'm in South Africa.
Although we want to have you in Nigeria more often, isn't it?
That would be very nice.
Yes. And then I'm also joined by Ken Afran, who is a partner in the turnaround and restructuring practice, also here in South Africa. Thank you very much, both of you, for joining us today.
Thank you.
Yeah.
Thank you for inviting us.
Yeah, thank you. So I think the first question that would come to everybody's mind would be when we talk about good companies failing, right? Because when the topic has to do with why is it that good companies in Africa that typically will have good turnaround plans fail? So the first question would be, when we talk about these good companies, what do we actually mean, especially within the Nigerian context?
So for me, I think a good company in a Nigerian, but also an African context more generally, means one that I think has good fundamentals, right? So the business model makes sense. It's in a good sector. There's growth prospects there. There's a number of things that's kind of going right for that particular business in theory, on paper. But the reality of the market that we live in and the world that we live in means that for a number of reasons, that company that should be viable finds itself in distress. Maybe that could be for a number of reasons. So some examples that I think Joe and I have seen in the past is the biggest one, the failure of management. So it's a great company, but is it being led well? Secondly, disputes. So disputes amongst shareholders, for example, it might be with key suppliers, key customers, it might be within the business itself, but disputes can often bring down great companies. And then the last one, I think, is perhaps the obvious one, particularly in our context, which is fraud.
I think capital structure also plays a part. It's like, do you have the right capital structure for the model of the business? I think we've seen some instances where that has tripped up what is seemingly a very good business. Again, I mean, it's like on a spreadsheet, a very good business. We've seen that trip up because the funding model is misaligned. And I think one of the biggest challenges, I think we've spoken about it many times, is when you're dealing with a business that is struggling, so it has a turnaround plan. I mean, by virtue of having a turnaround plan, it's gone through some form of stress, is that there's skepticism about putting the funding together for that particular entity. So that for me is also one of the core reasons. But I suppose number one is who's executing, and that's the management side. So, yeah.
And maybe on the funding side, just to touch on that, one of the phrases or things that Joe and I often say is banks will give you an umbrella when the sun is out. They'll take it away just before it rains.
Just before it rains.
So beware over leveraging.
Exactly.
Yeah.
I mean, that's interesting. And Joe, it's interesting that, we're not just talking about good companies, but obviously once you start talking about turnaround plans, that means the company would have gone through some level of stress. So the issue would now be, the company has good fundamentals in terms of good prospects of being turned around, but at the end of the day, they still fail. And some of the issues that you've highlighted obviously we will discuss that further down, would typically be the challenges around getting these companies back on their feet at the end of the day, and all that. And, you know, from a Nigerian perspective, right, we have a lot of these sort of companies, right? In fact, I would say one of the reasons that motivated me and, within the firm, and got the support that I needed within the firm to support this sort of podcast is that there's so many good companies, right, that would have ordinarily, in theory, good turnaround plans, right? And then at the end of the day, they fail, especially from a Nigerian perspective. And Joe, I know you've worked in the UK, and Ken, you too. So perhaps what do you see looking at the UK, for instance, looking at South Africa, for instance? Is that something that's a Nigerian problem, a peculiar problem to us, so that I would know whether I would need to start praying more often, right? Or is this something that you see, perhaps maybe in the UK, for instance, which is, one would say, a more matured jurisdiction for this sort of things? Do you also see this phenomenon?
So, I mean, I know that I've said many, many, many times, you can speak to any restructuring professional the world over, and we all have the same challenge. And so it's a universal challenge, and that is we get brought in too late. So I don't think that it's necessarily something which you can say in Nigeria, it's this. It is the world over that there are challenges in bringing the right people to the situation, because I think that's probably something else to explore. So getting there timeously to actually be able to execute on the plan. And why is that? And that's the optimism of management. So again, it's coming back to who's at the helm. Their optimism about their ability to steady the ship, right the ship. We're one order away from sales exploding. We just need to collect that debt. They said they'd pay tomorrow, checks in the mail. It's that impact of an inexperienced team in the situation, what I call the ego effect. So no one else knows this business better than me. I'm the only one that can fix it. Not on my watch am I bringing in some external consultants who think they can now suddenly turn this business around. Those are universal challenges.
You get that too. I'm facing that currently.
Absolutely, we get that. And actually, oftentimes, my response is, that's true. I don't know your business as well as you, but you don't know distressed situations better than me. So we join forces. It's work together, and we can do this. You've got to have the right skills for the right problem. And if your problem is you're facing financial stress, you need a restructuring professional to guide you through.
I think that's absolutely right, Joe. It comes down to human nature. What I would say is the main difference, as I reflect on specifically, my time in the UK versus my time here, a little bit of experience in Nigeria, is I think experience. It's how long have turnaround tools, especially legislated turnaround tools, been in play? Because in the UK, it's been around for such a long time. What we might call business rescue or administration, that is well understood. And it's often your stakeholders, particularly banks in particular, in the UK, will understand this is our playbook, okay? We're not just going to go straight to receivership. We're not going to go straight to our biggest bazooka and let's blow everything up. Which is, I'm not saying that's always the case in Africa, but it's.
But that's the case in Nigeria, I can tell you.
But there definitely is. There's a better understanding because the market is mature about the situation.
Exactly.
And what you're going to deploy into that situation, what you will accept and won't accept. Perhaps the risk appetite a little different because they understand the process. Not knowing a process like administration in Nigeria or business rescue in South Africa does cause reticence amongst capital providers, for sure.
I agree. Okay, so I would say, what then, given this thing, what then would you say would be the difference, let's just say one, right, between what you then would see ordinarily, perhaps in the UK, in the US, right? And then what you typically would see in Africa. So maybe let me put it this way. If you were to change one thing, right, over here in Africa, having worked on some cross-border mandates, for instance, what would you want to be seen done differently here in Africa generally?
I think the biggest one for me is reliability of outcomes. So in the UK, if you're a lender, for example, but also a director, you know that there is a real track record that if something goes wrong and you go into an insolvency process like administration, that there is a huge amount of case law, that you go to a dedicated insolvency court with a judge that isn't doing murder trials one week and insolvency the next week, but is highly experienced in what they do. And so you're going to get the same outcomes again and again. And I think that then gives an element of confidence in stakeholders to say, we can follow this best practice playbook. Whereas in some jurisdictions, in Africa, for example, Kenya, you don't have that reliability. You don't have that predictability because you go to court. It's going to take goodness knows how many years just to get to an outcome. The judge may or may not be au fait with insolvency law and so on and so forth. So I think it makes it then much more challenging. And then for lenders, you can understand then why they might become very risk averse in that particular situation. So I'd say a reliable system allows then for greater risk appetite and greater kind of inbound investment into distress situations.
And for me, a component of that is regulation. So if you also, in what we see amongst, certainly in South Africa, without a doubt in South Africa, is that we don't have sufficient regulation to ensure that those entrusted, those restructuring professionals entrusted to supervise distressed businesses are held to account if there is poor behavior and decision making. So that also brings in a lack of confidence into the system because it's a bit of who is your practitioner? We don't have the comfort that if they do something wrong, that there is a process to deal with that adequately. Whereas when you look in the very mature markets, their regulation is world class. And I remember that from when I practiced in the UK, just quality reviews of files and how methodical you needed to be about ensuring your case file was properly paginated and indexed. Now it was supposed to all be digital. It wasn't back then. But you were terrified because if your case got called for review, you could lose your license. If you hadn't properly recorded your decision making, you hadn't adhered to the statutory requirements. That is only just starting to happen here in South Africa. We've got a very long way to go. And I think it's going to be interesting to see how those regulatory bodies across Africa react and respond to restructuring professionals, administrators, business rescue practitioners who are perhaps not fit and proper for the job.
I agree. So, so listening to both of you, I think what jumps out for me is that if we have to get turnaround and restructuring, and we have to, it's important, right? It's been said that a good insolvency system is what would lay the foundation for good economy across
Absolutely.
Africa, right? 100%. So we have to do that. But what jumps out for me from what both of you have said is that we have to get the legal framework right, whether it's from regulation of the professionals to the actual insolvency system. It's important that we strengthen our system, our legal framework, our judiciary, in order to be able to support those sort of things. Okay, we've talked about this. Let's go back to the issue around turnaround plans, right? And I think, the first thing people would... So maybe we should take it from this point. You have a company that is distressed. I think the first question somebody would ask is, how do I know I'm distressed? right? So what would be the best time to call Joe and Ken in? I'll probably call good old Amala, right, in to come in because we've identified, and Joe, you've said it, that one big problem, and it's not just in Nigeria or South Africa, but it's general, is that we come in too late. You can't actually do anything at that point, right? And then obviously, if we look at how do we even determine when should professionals come in, then we then look at, okay, what's a plan? What does it should it look like? And then what would be the challenges? So maybe Joe or Ken, when should you ideally come in? Let me put it that way.
Well, you see, for me, the answer is actually in the legislation. It gives very good and very clear guidance on this. And from a South African context, it says, if you are unable to pay your debts as they fall due in the ensuing 6-month period, you are considered financially distressed. How do you do that? It's by having, my opinion, a very robust cash flow forecast. The number of times we walk into a business, we've been called in, it's really quite a dire situation, and we ask to see the cash flow. Crickets. There isn't one. There have been instances where we've walked in and found very good cash flow forecasts, and those tend to have fantastic outcomes, and there's a bit of a correlation there. But the ability to forecast your cash and to stress test it so that you are looking ahead and seeing the problem coming and really being honest with yourself about what are you pinning your hope on to turn it around. Sometimes things happen. I mean, COVID is a very good example where if you think about the cinema business, so Ster-Kinekor in South Africa went into business rescue. It was able to admit its, the audience on one day, and the next day it was not. You could never have forecast for that. But many instances, you can start to see the gradual decline. You can start to see that a portion of your, well, first of all, you probably need to go and raise an overdraft, but then a portion of your overdraft starts becoming sticky or hardcore, as we call it. Those are all signs that things are not trending in the right direction. And it's at that point that I believe it's the best time to engage with turnaround professionals. When you get to Friday afternoon, it's the 27th of February, and salaries are due, and you don't have enough cash in your bank account, it's too late.
Ken, assume that a creditor is listening to us and he says, oh, Joe has told the company when you should do that. You say it's a creditor. When would you want a turnaround and restructuring professional to go into a company? Because I ask that because I find that we say, oh, businesses, right, they take long. And to be honest, I can understand why. This is their business. They believe that, as you said, Joe, nobody else knows their business better than you. This quote and unquote, what they typically tell me in Nigeria, this is their life and blood. So when I look at it, I ask myself and I said, look, perhaps the better person to actually force this restructuring, quote and unquote, would be the creditor who would lose out when the company has gone under. So the question then would be, because I think from a creditor perspective, you would be in a dilemma, isn't it, right? If you go in too early, you are seen as being too cantankerous, right? I might be wrong, but that is what the fear of if you go in too late, obviously you are out of money, right? So could we theorize, right?
Yeah, and maybe we can stick to that theme, right? Because if you're a creditor, let's call it a lender, and you go in too early, what is the basis on which you are trying to call an event of default, right? Because you have a clear contract. If they're making payments to you, if covenants are not being breached, you can see things going wrong, but it's a challenging situation because what can you do? And equally, if you wait too late, then of course the challenge there is that you essentially are far too late, and you may be crystallizing a loss. So for me, the answer lies in monitoring, right? And this is specifically from a lender standpoint, much trickier, of course, from a trade creditor point of view. But if we stick to lenders, if you are, for example, the transactional banker of a business, you have almost perfect information. So the question for you is, what do you do with it, right? And the reality of most lending agreements is that there's a number of things in there that they can essentially leverage to act. So, for example, there are information undertakings. The missing of information undertakings is often the first signal that things are going wrong. Why can't they provide audited financials? Why can't they provide,
Management accounts.
management accounts? What is going wrong there? Where we've seen lenders do spectacularly well in later restructurings is they took very seriously those what you might call soft defaults early on. Maybe they then said, right, we need to take a closer look at the business. Maybe we get an external advisor in to do a business review. And based on that, we're actually just going to tighten things up. We're going to get more security. Maybe we'll reduce facility limits. We will take a credit view on what is happening in the business. We did a matter about 3-4 years ago where a lender went from being the transactional banker and the biggest lender in this particular group 10 years ago to being by far the smallest and covered in every single scenario. At the same time, the other lenders were massively increasing their exposure. So for me, it comes down to monitoring and then using those soft breaches as a way of then, putting a bit more pressure on management so that you can actually almost not force the restructuring, but, force action sooner rather than later.
Absolutely. And I think in today's age with, advances in AI, if you're the transactional banker, you really need to be leveraging that to create also a dashboard which allows you to see, who are my clients who are making round sum payments, frequently or on the same day every month. That's typically an indication of a payment arrangement. Who pays their revenue authority late? You can get all of that from the transactional data, and I think the speed at which those client names could be brought to the fore to say maybe you need to look into these is what impresses me most, I suppose, about the AI tools.
Yeah, I agree. I guess the question would be maybe specifically since both of you are from Deloitte, are there some tools that probably, because you mentioned heavily information, right? But the question would be, how do I then as a lender turn that information into action, or at least use that information as a guide? So are there probably tools or ways that a creditor or a lender listening to us now would say, okay, I can actually use this information to make a decision, right?
So there, I think it's very important. You've got a distinction between a financial creditor like a lender who would have access to underlying transactional data and perhaps a supplier, so a trade creditor. Their only indication is going to be things like order volumes and payment late, those are the only things that they're going to have to work with. We don't in South Africa work in an environment where private company financial information is made public. So you as a trade creditor, you're very limited, and equally taking action is expensive. So it typically is your financial creditors that would be the ones to start a process. It's very unlikely that it's a trade creditor. I can think of only really a handful of instances. But your lenders, especially transactional bankers, I say, they sit on a wealth of information at their fingertips, and I'm quite sure that within Deloitte there are some big brains who would be able to sit and work with what does that dashboard need to look like.
I think that's fine. Okay. I mean, back to the issue of the turnaround plan, right? So we've talked about how would the company know that they're in distress, whether it's a creditor, like let's say lender, igniting that process, or the company itself, recognizing that it needs help, and then you sit down and you craft this sort of plans. I think the question that comes to mind would be how important, for instance, would liquidity be in that scenario? Is that something that would make or mar your turnaround plan, for instance? How does that play into the entire scenario?
So my view, simplistically, is if you don't have liquidity, you don't have a turnaround. It's kind of as simple as that.
And binary.
it is. There's not many things that are simple in a turnaround situation, but that much is. So when we are thinking about, the mandates or the restructurings that we want to get involved with, before we take either an appointment as a restructuring advisor or as a business rescue practitioner, the first question we ask is, what is the liquidity situation? And if there are gaps, who is funding that? And if we don't have adequate answers to those two questions, we don't get involved, because we know that that situation will almost certainly lead to a failure, unfortunately. So,
but Ken, doesn't that mean that the company is going to commit suicide? Yeah? And then
we don't have a magic wand.
I'm not putting my money in.
No. The challenge is you would, get appointed. Now you're responsible. There's no money. What do I do? There is nothing to do. And that is why, having a toolkit of different restructuring processes and procedures is so important. So in Nigeria, having administration sitting alongside liquidation and receivership, because there will always be circumstances when actually liquidation is more appropriate. Because in the situation we're talking about, there's no liquidity. That's the answer. Unfortunately, you have to have, it's a cliche, but it's a cliche because it is true. Cash is king.
Of course.
Yeah.
Question one would ask then would be, how does distressed M&A play into those sort of scenario? But we can look at that later. I think we talk about liquidity as being important within this scenario. Sometimes when I think about it, let's say it's a company that's asset heavy, for instance, and so it doesn't have cash in terms of money, but it's able to attract financing. But then the problem, and this comes from experience, right? We're doing a piece of work with your team in Nigeria, and we are restructuring a company, sitting on probably about 50 hectares of land. So that's really massive, asset heavy, but also very leveraged and stuff like that. But it's, to me, in terms of from a practical perspective, what would be the ideal plan would be to unlock the asset, right? That's already land, so it's to unlock it, do development and all that. But we've been able to attract financing, not because we don't have a good business case. We've been able to remove the management. The management, obviously, they became suspended when we went in. The company went into process. We're using administration. But we're not able to attract financing simply because the business is distressed. So nobody wants to talk to us. It's like, So the question then is, liquidity, cash is king, but why is it that in Africa, it's very difficult for you to attract new money, even when you have good turnaround plans? Why? I don't know what your experience has been in this instance, and why do you think that's happened? Because if you look at the more matured market, again, the US, UK, for instance, there's a distressed lending market.
Absolutely.
That appears not to, at least from Nigerian perspective, it doesn't exist at all. So,
and I think the same is true in South Africa, and we've had business rescue as a process. It'll be 15 years in May.
Oh, nice.
And we still don't have what I would say is a fully functioning distressed debt market. We absolutely have lenders who will fund distressed situations, but they also aren't going to get in themselves into situations where they weren't already exposed. So they are funding the process to also secure their position. So we do find that, but we have very few funds, whether they're alternative credit funds, distressed funds, private equity, that have a distressed focus. We have a lot of people saying they're interested, but very few that have actually followed through. And it's a challenge. It's a very big challenge, because when you're sitting with a situation and you think, well, who do I call? And we had a matter also about 3 years ago. And I remember doing a long list of everybody that I knew who had told me they were interested in funding distress situations. And we went through them one by one, and no bite. Again, a situation a couple of months ago. We're in for distress. Present a matter that's in business rescue. No. So it's a big challenge, and I think particularly organisations like the IFC are really trying to push for a secondary sort of debt market through their distressed asset recovery platform. They call it a DARP. The challenge there is you need matched funding. So again, it's, there's a challenge with that. But I do believe the fundamental issue is what Ken spoke about earlier. It's confidence in the process, confidence in the outcome. They understand that all the stigma associated with being in administration, that, you're dealing with people who typically look at vanilla credit. And so now you're asking them to completely shift their perspective to a distressed situation. And they haven't seen it enough times. So again, that time aspect, experience, they haven't seen it enough to trust that this is a good deployment of capital and they will get their money back.
And I mean, we were all at the Insol Africa Roundtable last year, and there was a fantastic speaker who was actually a distressed debt funder.
Not me, right?
You're also fantastic, don't worry. and he really outlined it beautifully. He said, every year that I don't get my return on investment makes a massive difference to the returns that I get. So if I'm now stuck in court for 2 years, 3 years with an unreliable output, why would I put money into this distress situation when I have alternative places to make the investment? So I really, for me, it comes down to the reliability and the speed. And one of the things that gives me a lot of, that I'm very happy about over the past year in South Africa is that we do now have a dedicated insolvency court. And that just will reduce the amount of time that it takes to resolve matters. But I think in most African jurisdictions, to be honest, if I were a distressed debt investor sitting in Europe or wherever, I'm not sure I would look at those situations either until the environment is fixed.
And the other thing about a dedicated insolvency court is that you have dedicated judges. So you've solved the problem of I'm a criminal judge this week, human rights the next, family law, and a bit of insolvency. And I think, when we look at that and we look at then the role that the profession has to play, it's also making sure we're supporting the judiciary, that there's adequate sort of knowledge sharing opportunities. I think there's a lot of it where we need to come together to ensure that everybody is all up to speed on latest case law. It really helps, again, just in the confidence.
I mean, it's quite interesting to know that South Africa has a dedicated insolvency court. So that's like in the US,
Brand
for
new.
instance. Less
than a year old.
Yeah, in the US where they have the bankruptcy court, right? Even in Nigeria, we've been really advocating that. Even if so, in Nigeria we have the Federal High Court, which would typically deal with issues around pure insolvency, right? But as you said, you've got a judge dealing with tax, maritime, and then administration. It becomes so. What some of us have been advocating is, even if you don't want to give us a dedicated court, at least the assignment of cases, in terms of rostering, we can have people who are dedicated insolvency judges, right? Such that,
Yes.
it makes common sense that if you are a judge whose interest is in maritime, for instance, or tax, for instance, or intellectual property, you might not have an interest in insolvency. And these are complex legal issues that you have to deal with. And as you said, these are issues that investors would want to typically look at in order to say, okay, I'm going to put in money here because they need predictability. Nobody's stupid to go and put in money in a jurisdiction that you're not able to predict what the outcome would be, whether the decisions would be in a certain manner, right? But one thing I hear, again, over and over again, would be predictability. And if you look at it from a broader perspective, the sort of legal framework that we have in order to be able to advance. Having an insolvency system, having a turnaround and restructuring framework without having the liquidity to fund it, as you said, Joe, it's just joking, right? And it's really frustrating, at the moment.
Well, for us, it's also it's having all these professionals, and we don't have a regulatory body big enough or well enough resourced to cope with it. It creates the same challenges.
Exactly.
Yeah.
So the question that probably would come to mind would be, what is it that the typical European lender or American lender within the distressed debt market would have? What sort of protections that they would typically have in the UK, in the US, for instance, that perhaps may be lacking? And it might not be South Africa. I mean, you have a more matured system, but what are those things that, if I'm a lender sitting in the UK and I see that at least play out, even if it's on paper in Nigeria, for instance, then I would say, okay, so things like super senior credit status. So what sort of things would you?
Do you want to go?
Yeah, sure. Yeah. So I think there's a commercial point I just want to make before that, but it's an important point around the legislative framework. But I think the biggest thing that is attractive about European markets is that you can buy in at the right price. Because the price that you buy in at is, of course, like one of the biggest determinants of your return. And what we have noticed time and time again is there's a mismatch between where a distressed asset investor may want to come in versus what a lender believes their return, where they think the price should be. And they're just being a gulf between the two. So if you don't get that right to begin with, I think it's a much more challenging situation. But if I then look at some of the statutory tools available in the UK, one that I would point to, for example, is the UK Restructuring Plan, where you, as now the, let's say you're the distressed lender, you've come in at the right price, and you're perhaps the biggest lender, or at least you've taken super senior security, and in most scenarios, you will get repaid. However, in a liquidation, most other creditors will not get repaid. In that situation, you can do what's called a cross-class cram down, right? So, in other words, that there is a tool available to protect you, and you can take that through a dedicated insolvency courts that will give you an answer, often within a year, and that gives you a lot of comfort that even if the worst were to happen, you don't have to go straight into liquidation. You can actually apply to the courts, have this UK restructuring plan. And I mean, we've seen it on a couple of matters now where it's actually African companies that are applying to the UK court.
Yeah, I know.
And them being able to, get a good outcome from a distressed asset investor perspective. Now, if you're sitting in South Africa, for example, you don't have that. You don't have that protection. You're actually at the mercy, in some cases, of the general body of creditors. And that could be small trade creditors, that can be relatively unsophisticated players. And so, that's just one example of an instrument that is available in the UK that I think encourages distressed investing.
Yeah, and I suppose the one that I think of is, you also need to just understand the South African credit environment. So our banks, we have few of them, but they are generally very well secured, right? They'll take everything. So whatever is available as security, they tend to wrap up for their lending facilities, leaving virtually no unencumbered assets for somebody else to come in. But in the US, in a Chapter 11 scenario, the lender that comes in to fund not only gets super senior status, but can what we call prime the other lenders, provided there is adequate protection. And that for me is, phenomenal. You mention that in the South African environment, and you'll have, oh my goodness, you're going to derail the whole credit system. Cost of credit is going to go through the roof. And I don't believe that to be the case, because adequate protection is about valuation. And provided you have the checks and balances around valuation, a lender should be no worse off. It's just about the additional security that they hold, the surplus security being given to the person, to the fund, to the lender who's prepared to come into this very precarious position and put more money in. Typically, it means that it forces your existing lenders to be that funder because they don't want to give up. Yeah. But again, they're confident in making that additional lend because they've got adequate security. So that's something I wish we could see more of on the African continent. It just does require lots of checks and balances because it cannot be abused. If it is abused, then the arguments about cost of credit absolutely hold true. But the ability for somebody to come in and with a surplus security be secured and rank ahead, I think is important in terms of dealing with risk appetite.
Okay. I mean, from a practical perspective, I'm just thinking of from a Nigerian perspective, I think a creditor would rather jump off the bridge than we're dealing with one. But I think what that would encourage would be creditors putting in more skin in the game,
Correct.
which is something. So the default too is once a company is distressed, and to be fair to creditors, companies also don't make it easy for themselves because most of them will start fighting the process. But if you know that, look, I don't want another creditor, coming in, and you also trust the process, and that's why I agree to that it's important that we have the right process and we have the right professionals guiding that process because that's important. Then maybe even the likelihood of having these new persons coming would encourage the creditors then being able to put more skin. But just because I talked about professionals, and and Joe, you've highlighted the point about the restructuring and turnaround professionals playing a part in this entire thing. But maybe to dive deeper, do you think that the quality of turnaround and restructuring practitioners matter, right? Do you think they play a significant role in the success of a turnaround and restructuring plan?
Absolutely.
And perhaps, do you think that having better, more equipped professionals would also enhance the restructuring
perceptions and outcomes, without a doubt. And again, perhaps I default to my training because I started in the UK. And there, to be an insolvency practitioner, and there an insolvency practitioner covers administration, receiverships, liquidations, voluntary arrangements. You can do it all if you've got the license. But to get the license is very tough. The exams are difficult. You have to prove that you really have a good understanding of the law. And knowing the law is one thing. I think I've always said there's a qualitative aspect to this, which is equally important. Restructuring is just as much about people as it is about law and numbers. But you need a barrier because otherwise you are dealing with livelihoods at the end of the day. You are dealing with a business that is on the edge. You have to have the right skills and qualifications. the ability to, whether it is even negotiation is the skill that is needed, to be able to pull whatever lever is necessary to try to bring it back from the brink. And if the start of that is an education barrier, personally, I'm all for it. I think you can't have somebody who thinks this sounds like a good gig. Let me give it a go. The risk is too high.
Let me wing it.
Let me see what this is all about. They seem to be making, some good money.
Yeah,
I want some of that too.
Exactly what is happening in Nigeria, right?
And that's very dangerous. And that's when, again, you overwhelm your regulator because suddenly you're licensing too many people because there's no barrier to license.
Exactly.
You can't then control them. So,
I mean, sorry, you just made a very important point. So I think even in Nigeria, it's a thing of it's a thing of pride to have more. I mean, you get to hear, oh, we now have 1,000 more admittants to as insolvency practitioners. So and listening to you and thinking about it, I don't even think it's a good idea because it's like bringing in, you're not sure of the quality of persons. People just say, oh, Amala appears to be making good money out of this. I need to find out what this is about, right? And then,
you should be celebrating how tough it is to become an insolvency practitioner. Agreed. And I come back to one of the earlier questions that you asked, which is, why do banks or lenders not fund turnaround situations? And often one of the reasons is they've been burnt in the past. They've been burnt. They don't want to put their money in the hands of a practitioner who may or may not be equipped, who may or may not be ethical, actually, even. So I really do think that we should be making it much harder to become an insolvency practitioner. As Joe said, it's I think one of the critical things that we need to solve for. And then you need
the support around them.
Yeah.
Because my goodness me, it's a really tough gig. And I think there needs to be more support for those that are ethical, that are qualified, that are really good at their job, because you don't want to deter those that have the skills and qualifications, because it's a bit like all the knives are out.
Okay, I think the question would then be, I mean, what would be the attributes of a good insolvency practitioner, or maybe a turnaround and restructuring practitioner? Let's say somebody listening to us now and say, my goodness, I like what these guys are saying, but what would be those attributes that perhaps even as a message to regulators, right? Because I tell you, they would be listening, right? What? At least I know from the Nigerian perspective, right, that our regulators do listen to. At least I know they listen to the first edition, so I'm sure they will listen to this one. But what would be the attributes? Maybe to put it this way. What is it that makes a Joe, a Ken successful, right? And maybe hopefully an Amala, as a turnaround and restructuring partner that, from the rest of the pack,
I mean, I think there's some obvious determinators, and that's, I think, easily quantified. For me, the one skill that we don't see often enough is knowing what you don't know. So if you are brought into a situation where, and maybe I'll speak about myself personally, I'm not a lawyer. I might be a wannabe lawyer. I love the law, but I'm not a lawyer. So when we're involved in these situations, we make sure we bring brilliant lawyers along the journey with us, so they can provide that legal expertise, which we don't have. We know that. When no one's going to let me loose on drafting an agreement. So that for me is a really core skill that I would like to see more of. That you don't try to also, again, wing it in a sector, in an industry where you have no expertise. Bring somebody in who knows. Costs a little, but I always turn it around and say, can you afford not to? because those insights might save you a whole lot of money and time and energy. And yeah, without that, you wouldn't know. But
I would absolutely agree with that. And I would add transparency. Because when you're appointed, that's your day one. But for the stakeholders, it's day 1,000 or day, 2,000.
The normal thing that they've probably heard times.
Well,
and
they've
times
been
and
hearing
times.
the same story over and over, and now you've got these new people in.
And
So
then
what?
And it's been broken promises and broken
Exactly.
promises and broken promises. So if you then continue that, especially in those first few weeks, you're going to lose those stakeholders. And it's going to be then very challenging to get them back. So being transparent, communicating with them, hard as it is, it really is hard. But that stakeholder management piece, I think, is incredibly important. And when I think about some of the complaints that we hear from lenders, it's, we didn't hear from this practitioner. They were doing X, Y, and Z, and we didn't know about it. And that is what I think undermines the credibility of the profession, because we're in a space here on this continent where these tools are still relatively new. So each of us that takes on these appointments, we're actually flying the flag for the whole industry. And it just takes a few bad apples doing the wrong thing, then it landing in the news, and then now the next CEO or the next director will say, I don't want to go into that process.
So, I mean, I hear you and it resonates. And the question would be, so would you say, because you talked about stakeholder management, would you say that as a restructuring, that, or perhaps to put it this way, how would a restructuring turnaround professional align from a practical point? I mean, I'm sure we have war stories, align stakeholders, right? Because it's very critical that you carry your stakeholders along, but in practice, it can be very difficult, especially where you are dealing with. I have something that we are doing at the moment that we have about 30 creditors. And, from a practical point, I didn't want them to have my phone number. Otherwise, you probably have a creditor whose board is probably giving him a rough time, and then he will come out and call you. And you will be like, from where to where? How am I getting this hiding? Absolutely. So the question would be, how would you align your stakeholders, right?
So what I would do is start with the end in mind. So what are we ultimately trying to achieve, and who do we need to achieve that? So in a South African context, for example, you need 75% in a business rescue situation. You need 75%.
Yeah, same as Nigeria.
Same as Nigeria. So who are the creditors that make up that 75%? Like straight away, that in many situations, it will be a handful of banks, maybe one or two large trade creditors. So those are the people that you're targeting straight away. When we come into mandates, what we typically would do is we will have meetings with each of those key stakeholders ideally within the first 48 hours. If that's not possible, then within the first week. Because one of the superpowers is you're new. You're kind of like the referee. You can come in, you can say, what are your grievances? What's happened? What are your objectives?
A little window.
Exactly.
Yeah.
And that can also build trust. What is it that you've been frustrated by? And think to yourself, like, are there easy wins? Can I deliver one or two of those things within the next week? So, for example, they might say, we've never seen management accounts. Okay, then we can move heaven and earth so that they can see management accounts within that first week. So it's things like that, just looking for what's the low-hanging fruit from a credibility boosting perspective.
Yeah. And then it comes back to your word transparency. So what we tend to do is we would get those common stakeholders into a call, a frequent call, one that's set up every fortnight, whatever it may be, where we would take them through what are we busy with, what are the challenges we're experiencing. They don't have to attend. Some may say that's, oversharing, it's too much. But for us, it's a very useful tool to say, this is the journey, this is where we're at. These are the challenges we see, these are the wins we've had during the week. This is how we think we're tracking in terms of overall progress. And it gives them an insight into what we're doing. It also does, unfortunately, I'm going to mean that my phone rings a lot because in those big forums, and especially now in Teams,
Mm-hmm.
nobody says anything, but they'll phone you afterwards.
I said, I didn't want to say this, but let me just tell you now.
Yeah, but you can't get away from it. It's a people business, and it's allaying fears of people. You know, whether you're dealing with a group, a large body of employees who are all worried about, will they have a salary next month? Are you dealing with, you know, some very sophisticated financial creditors who actually quite passive in the situation, just want to, you know, when do I get my money back? Are you dealing with a whole bunch of suppliers who run their own businesses, who now this is impacting their ability to continue? You know, you need to meet the people where they're at, and take them on the journey.
Maybe the last thing is be careful with what you promise.
Yes.
I think one of the most powerful things you can say is, I can't promise that, but, and then what could you actually achieve? Because as soon as you make a promise and you're breaking it, then you're stepping into the shoes of
Absolutely.
the previous management.
Can you at least promise you're going to get their money back?
No.
because
Never.
that's the question. So when I say that, they'll be like, okay,
I will do
hear
my
you,
best.
I hear you, but can you promise me you're going to get my money back? You know.
What we can promise is we'll move mountains.
I promise
We'll
you
try
have
to.
all my energy and attention.
Yeah.
Exactly. Okay. I mean, we've talked about all these things, but you know, one thing that then comes to my mind would be, we've looked at the framework, we've looked at, you know, the practitioners, we've looked at, but I think one thing we haven't touched about would be the directors of the company, right? So how often, right, you know, from a practical perspective, perhaps, would the company, the management of the company, be a barrier to a successful turnaround plan? You know, is that something you see in fact, if we are dealing with 100 cases, perhaps 90 of them, we have the companies themselves fighting us. Not just, you know, there's a difference between fighting and then voraciously, right? You know, putting your name in the papers, sponsoring publications, and you are in a state of distress, and then you have enough money to actually sponsor a publication. Wouldn't you take that money to go and pay the
your
credit,
employees.
you know, and all that? So how often does that work? Does that happen here?
So my view, and again, just mirroring or thinking about my experience in the UK versus here, I think restructurings are much harder in Africa than they are in the UK.
Of course.
Because in the UK, what happens is lenders will essentially force out the old management team, bring an interim team in, then the negotiations begin. So it's just a prerequisite. You haven't even started negotiations.
Well, you said earlier there's a playbook.
There's a playbook.
And that's the playbook.
And that's the playbook, exactly. Whereas in African restructurings, whether it's in South Africa, and a lot of what you're saying resonates, you know, with some of the mandates we've been on, management teams can be one of the hardest hurdles to any restructuring, because they almost always are the ones that have been there for a period of time.
Of course.
And so they may see someone coming in as a barrier for whatever reason. So they might see you as being the bank's person, the spy, you know, all of those things. And it is extremely challenging to deal with. But the point around trust, I think, also applies not just to your creditors, but it applies to the management team. So we spend a lot of time, and to be honest, losing a lot of sleep and grey hairs, just dealing with the personalities of the management team.
Exactly. And this is somebody you are supposed to help, right? And I tell them, I was having a conversation with somebody, I'm sorry, I'm emotional.
I'm feeling you.
I'm going through something at the moment. I'm like, this is literally somebody who, you know, should be rolling out red carpets for me, because
And say thank you.
We've been appointed to come in and save you from
Absolutely.
even embarrassment. And then you are doing this, like, make me understand in what planet that works. But I think that's also, and I think, you know, Ken, I'm sorry to cut you, but I think it comes from a fundamental problem with, and perhaps it might not have been a good thing, right, for us to adopt certain principles under English law. Under English law, it's a firm principle of law that you have a company, you have the directors, but there is separate legal personality between the company and then the shareholders. These are two different entities. In Africa, I would theorize that the concept of a corporate legal responsibility, personality is blurred, such that however you see it, the shareholders, the directors, ultimately sees themselves as the company. So there is actually no business without them as the directors and as the shareholders.
Absolutely.
So there cannot be. So when I think about it, I ask myself that perhaps this issue isn't really an African problem as an African restructuring problem in terms of attitude, but may actually be a fundamental problem with our understanding of corporate personality. That for us in Africa, maybe there is actually no distinct corporate personality between the company. And it happens very predominantly in family-led businesses. So, the son of
Interesting theory.
the son of the founder, let's say the founder has died, believes that this is his family's business, and without the family, there's no company. So you can't. So talking about things about
Selling the business.
it's it's alien, it's strange. You are bringing in things because this sort of reaction. I tell you, we work with Deloitte a lot on some of these mandates in Nigeria. You can look at the statistics. I think it's probably 2 or 3 companies that have actually said, you know what, we are in problem and we appreciate you coming in. In almost all circumstances, all of them would fight the process.
For us, we found something quite similar in your more sophisticated entities, your listed entities. There is a clear distinctions, and so it is very much thank you. In your, move into the private companies, the smaller companies, what I would say are more business banking size companies, it's not that. It is, as you say, one personality. And one of the options available to a restructuring professional is a sale of the business.
Of course.
Can't do that. So your options are limited. And there, being able to work with the management team is critical to success, because if you're going to fight each other,
Yeah, of course.
And you have to show, I think, extraordinary patience and resilience and emotional intelligence, because I think the easiest thing to do is to butt heads, right? Is to adopt their stance, because their stance is aggressive, and so human nature says, "I'm going to respond in kind," but that's never going to reach a good outcome. So I think all you can do is be consistent, okay, and professional, and resilient. Because it's really, those are the mandates that you really get grey hairs over, because those are very challenging individuals. They're not going to say thank you at the end of the day that you've saved their business, but you kind of have to, in your own self, go home and say, you know what, I've done a good job here, and I know that. Some of the creditors know that, but there's not going to be a ticker tape parade for me here.
Absolutely.
Okay. The question would then be, I'm sure there would be companies in distress listening to us, and they've listened to all we've said. What do we say to them? Because they have. I try to see things from people's perspective.
Absolutely.
I mean, this is a Joe. I've never met Joe all my life, and she just comes in and says, I've been appointed, or let's say Anna, for instance, I've been appointed by the court. I mean, literally, you are in your office and then somebody knocks, and then says, probably with bailiffs, and and when I appointed an administrator, we have people going and literally never met him before. Maybe you've heard about somebody with that name, but so the question would be, so there's actually that genuine grounds for suspicion, for trying to fight the process, to say, I don't know whether he was sent by the banks as a spy to come and take over. And again, in Nigeria, it's a country that was the entire corporate law up until 2020, which is just less than 6 years ago was a pro liquidation, pro receivership, pro sale, pro killing companies approach. Even up till now, it still is. It's just that
Takes
we're trying to.
time.
It's just that's why we're doing this sort of podcast. So the question would be, what would you say to that company that's going into distress, that just has somebody who has just been appointed to restructure the company? What would you say to him to allay his fears or her fears, right? What would you say about the structure? I know that's a difficult one, isn't it?
Yeah.
It's a difficult one because there's maybe let me give you the human answer. Is I would say give it a chance. Okay. Because I think it's easy to immediately adopt a stance of they're here to sell the business from under me, or there's all sorts of suspicions that will come into your mind.
Of course.
And it may be fed by what's come before, because again, this is their life, this is their livelihoods. So what I would say to them is get to know the practitioner. Maybe ask around to see what is their reputation in the market, and give them a few weeks. Don't just go straight in adversarial. See if actually there's something you can get from it, because you might learn something through the process. You might end up with a business at the end of the day that is sustainable, and ultimately you as the business owner benefits from that. They don't benefit from that. Yes, they get some fees here or there, but really it's you as the shareholder and owner and manager of the business that ultimately benefits from this business continuing into the future.
I agree. Okay. I mean, I think we've spent time on this topic, and probably we'll start wrapping up. And wrapping up, I think what would come to mind would be, if you would want to, let's say you have a magic wand, right, and you would want to change something within this market. I know we've said a lot of things. We've poured out our hearts. I've poured out my heart. I've poured out.
We'll have a chat later.
Yeah. Maybe I need to seek therapy one of these days, because, but...
it's one of the skill sets of a practitioner,
exactly.
being a therapist.
Exactly.
Absolutely.
Right. I mean, you're quite, because you get to hear people, pour their frustration, creditors pour their,
worries, their
of course, the company itself. And, don't mind me, we have had instances, like I said, even when they fight and then they realize, and they calm down, and then they open up to you, start telling you life stories, how he started the business in the 70s, how he started it with a cent, and he's been able to grow it this way, and, those challenges. And it's important to hear those challenges, because in trying to pick those sort of things, you then perhaps identify what the problem would be. Sometimes it might be that this is actually a business that has passed its prime. The market has overtaken it. And this person is just being sentimental about it and just needs to move on, right? There's no market again there. And, or you then realize, this person is holding on to this business, and it's just a matter of probably bringing in new persons to partner with him and then grow the business. So those sort of things. But if there were, back to my question, if there was something you would want to change, right? What would that be? One thing, right?
Can it be a one that goes across Africa?
Yes.
Because what I want for all of Africa is a speedy process. So if that is resolved through a dedicated insolvency court, that's what I want.
Hallelujah.
Yeah, because you're never going to win the argument around confidence and reliability and predictability and all those good things if you're stuck in a process in the court for 4 years. So if I could do that across Africa, that's what I would like. I think we've got a model that's working here in South Africa, and it's interesting, Amala, because it's not we say it's a dedicated court. It's actually a dedicated court role. That's what it is. So it is just they've prioritized insolvency matters and have dedicated judges.
I mean, if you don't mind me asking, how were you able to achieve that? Because
we had forward-thinking judiciary. So it's a pilot project in Gauteng. It's now being extended up to Pretoria with a vision that it's going to apply to all the high courts in South Africa.
How does that work in practice? Let's see whether that can apply in Nigeria.
Well, I mean, now you're testing me. So if an insolvency matter is enrolled in the Johannesburg High Court, or Gauteng, I think as it's called, it's identified as an insolvency matter and gets put on a separate roll.
Okay.
And there are rules about when that then needs to be heard. And they follow that application, let's call it, through with those rules, such that it will be heard within a 4-week period, and you should have a judgment expeditiously, because the judges who are assigned to this specific role understand and have an interest in insolvency, and so know that there is no such thing as taking your time. We need speedy decisions and judgments, because we don't have the luxury. Time is money, and money is generally very short in these situations.
I agree. I mean, in Nigeria, what we fought and we were able to get, but I don't want to say it on this podcast, is,
But you are.
I mean, I have my comments on whether
Edit.
it's effective. So I don't want the supervising judges listening to this podcast and saying, "Abala, what are you saying?" But what we have is now an insolvency registry, right? And we actually have a head of that in Abuja, within the Federal High Court, right? Where ideally, when you file insolvency matters, it's identified as an insolvency matter. It goes through a track. And then it's supposed to be assigned to at least judges who have interest in insolvency. But don't ask me whether that plays out in practice, But hopefully we're getting that. I think it's a step in the right direction.
Absolutely.
And,
We've proven it can be done.
Exactly. And
Because
I think
for many, many years, it was a pipe dream. And actually, it came together very quickly. It just needed the right-minded people with the impetus and momentum to just get it done. And in the end, it was probably a 6 to 8 month process. But we had spoken about it 4 years.
Yes. I mean, to be fair, I have to say this, to be fair, and this is not, because I'm from Nigeria, we have very brilliant Nigerian judges. I tell you this because, this is what I do for a living, right? Turnaround and restructuring, and particularly administration, right? And we've seen, at least in things that we've been involved, we've seen very brilliant, decisions supporting the process, because it's one thing to have the process. It's another thing having a judiciary that actually supports the process from a commercial point of view. I mean, if you have a decision, we're talking about distressed debt market. And if you have a decision that does not recognize issues around super senior credit status, then obviously you know that you're never going to bring in an investor, bringing in new money, right? So, but we've seen very brilliant rulings come out. We've seen the sort of support. I think with certain, obviously, judges who have interest in this process, it's never, it's not possible for you to have all judges have interest in the subject matter. It's like, I don't have interest in maritime, for instance, right? So I think it's simply about having the right persons decide these cases, and they would look at it fairly. And so I think it's interesting what has happened in South Africa, and, obviously going back to Nigeria, I would take it home. And, we would heavily try and see how it counts. We have a chief judge of the Federal High Court who has been listening as in Nigeria with BRIPAN. We've had audience with them, made proposals and all.
But that's why, for me, initiatives such as the Insol International and World Bank Africa Roundtable are so important, because the day before our part, the judges get together, and you had Deputy Judge President Roland Sutherland attending in Cape Town last year, and he is the brains behind our pilot court, so he can share What did he do? How did he make it happen? That we call it a court, but it's actually a role.
Mm-hmm.
He can give all those nuances. And I think that's for us in Africa, that round table and the ability to bring judiciary together across the continent facilitates the sharing of ideas, of innovation. Really looking forward to this year.
Yeah, I mean, what we're doing is to encourage more and more from the BRIPA, and that's the professional body, encouraging more and more judges. I think we've had, every year we have judges coming, but, more and more so that when we get back to Nigeria, we're able to say, this is what is happening in South Africa. Because if you say this is what is happening in England, it sounds a bit far. But if you say this is not what has happened in South Africa, we need to bring it down home. And even in terms of the regulations, because I currently chair the committee reviewing the law and, helping the Companies House, which is the Corporate Affairs Commission, improve on this thing. So some of these things that we've discussed, we can implement it there. And hopefully, very soon, we have a young rescue mechanism in Nigeria. But I'm sure we Nigerians are very enterprising. So very soon we will start exporting some of our experience to South Africa.
Good.
Right?
Absolutely.
Yeah. Ken,
Yeah.
with you, what would be the last so that we can?
Yeah, I think if I was to have one wish now, it would be unified legislation. So
Are you talking about on Citra model law or?
that's ultimately where I think we need to get to, because even within South Africa, you have to look at kind of 3 or 4 different pieces of legislation to kind of almost like a puzzle piece, jigsaw piece, put together what our insolvency legislation actually is. It isn't in one act. So unification within South Africa, I think, is really important. But then a model that spans the continent, so that if you're practicing in Nigeria, you have an appreciation for, let's say, the Kenya legislation and so on and so forth. So something like as you said, antitrust, for example, coming in, absolutely coming in, and having that kind of unified framework will be a big step forward. Because if you're, for example, dealing with a multinational that has entities in a number of jurisdictions in Africa, at the moment it's a nightmare, because you're not able to you basically have different processes, utterly different in every single jurisdiction. So I think some way of uniting, firstly within countries, but then cross border is what I would love to see.
Yeah, I mean, time is no longer on our side, but just because you mentioned this, in Nigeria, when we were drafting the Companies and Allied Matters Act, which is the Nigerian Companies Law, CAMA, there was a whole debate. I can remember we were being supported by World Bank around cross-border insolvency, Stren model law. And the Nigerian practitioners, were very, very against it because they don't want a Ken or a Joe, right, coming to Nigeria to take the work from them. And so, we definitely have to look at the wider issues, right? But what would you then say, right, to somebody in another, because it's not just Nigeria, I'm sure there are other countries where there will be that fear. I don't want a Nigerian guy, coming.
Well, we see it in legislation that you have to be a specific, I'm just going to use South Africa. It's not what our legislation says, but, if you want to be a business rescue practitioner, you need to be a South African. We see that in legislation across the continent.
Yeah, because
my counter argument to that would be, you then get sharing of knowledge, sharing of expertise, sharing of information. Because I think when you're insular, when you have 54 countries, or however many countries we have on our continent, I think it's 54, each acting on its own. And then you have, for example, the EU, which is essentially one, which is going to be more successful, because ultimately having good insolvency legislation, good insolvency practitioners, it's an engine for economic growth. So I really don't think we should be protectionist in that way. I think it's actually holding us back in a number of ways.
I agree.
All right. Thank you very much, Joe and Ken. It's been such an interesting discussion. I wish we could go. There's so many things that we could have talked about. I had to just limit a number of things, but I think it's been really interesting. I mean, that's what happens when you have two power houses, come in, put both of them in a room to discuss such a very pivotal issue. I think we need to just get it right as a continent, right? There's so many distressed businesses, and we can only, and it's very important for the economy. We need to get these businesses we need to get them turned around. We need to get them restructured. It's important for the economy. It's important for jobs. It's important for our GDP. And so I'm very grateful for the both of you for coming. Hope to speak to you soon. Thank you very much.
Thank you very
Thank you.
much.
Thank you.
It's a pleasure being with you.